Good evening, everyone. It is my pleasure to welcome you all to the second panel discussion of the National Conference on Cybercrimes and Artificial Intelligence. The theme of this discussion is data privacy and cyber threats in the age of AI versus cybersecurity. We are joined here today by four of the most eminent experts in the field of cyber laws, data privacy, and cybersecurity. Firstly, we have our esteemed moderator for the discussion, Mr. Na Vijay Shankar, better known as Navi Sir, who is chairman of the Foundation of Data Protection Professionals in India, founder director of Cyber Law College, the pioneer virtual education institution in India dedicated to cyber law education, and founder of www.navi.org, which is actively involved in emerging fields of cyber law. Navi Sir is a cyber law expert and a data governance and protection consultant based in Bangalore with nearly 5 decades of experience. He has been involved in the conduct of many seminars and workshops on various subjects including cyber laws. Navi Sir is the author of the first book in 1999 and first e-book in 2003 on cyber laws in India, as well as many other books on cyber law, data protection and privacy, and cybercrimes. He has introduced several innovative concepts such as Cyber Evidence Archival Center, Personal Data Compliance Standard of India, and Data Valuation Standard of India. He has also been a member of the IT Act Policy Advisory Group, Ministry of Information Technology, Government of India. He is presently the member of E-Governance Advisory Group, Karnataka. Navi Sir is a visiting faculty in several educational institutions including Nalsar, Hyderabad, and NLSIU, Bangalore. He is also the founder secretary of the Cyber Society of India, founder trustee of the International Institute of Information Technology Law, and founder chairman of the Digital Society Foundation. We're also joined by Dr. Ranjit Omen Abraham, teaching faculty at the Tamil Nadu Dr. Ambedkar Law University, Chennai. He has a postgraduate degree in business law from the Tamil Nadu Dr. Ambedkar Law University, Chennai, and holds a doctoral degree in the topic titled Digital Infringement of Copyright with reference to film and music industry, a critical study. He was selected by the US Consulate for the prestigious IVLP in intellectual property rights in 2008. He has presented and published various articles in topics relating to intellectual property rights and business laws. He was elected as Fellow of the Indian Society of Criminology in the year 2018 and also elected as a Treasurer of the Indian Society of Criminology. He has been teaching cyber laws at SOAL for more than a decade. Next, we have Dr. Ashok P. Vajay, Associate Professor of Law and Associate Dean at TNNLU, Aurangabad. He was awarded a PhD in cyber law by Symbiosis International University, Pune, and is also a postdoctoral research fellow in cyber law, pursuing an advanced research course, LLD, in the field of law. His areas of interest are cyber law, family law, intellectual property rights, and law and women. He was invited by many governmental, semi-governmental, non-governmental agencies, various national law universities, and leading law schools as an expert in the field of law for various assignments such as resource person, chief guest, guest of honor, expert invitee, guest speaker, judges in several national level moot court competitions, and as a panelist in several national and international academic programs across the country. Dr. Ashok is also regularly invited to consult for the National Commission on Women, parliamentary standing committees, state commissions, the Ministry of Law and Justice, the Bureau of Police Research and Development, the Ministry of Home Affairs, the Government of India, as well as the UGC HR Development Center. The District Legal Services Authority and even courts and the police officials also consulted. He has provided training to judicial officers, attorneys, and judges from India, Nepal, and Bhutan. He has around 30 publications to his credit in the form of research papers and articles in several reputed national and international journals and books. Finally, we have Advocate Karthikeyan from the Madras High Court joining us. Advocate Karthikeyan is a renowned cyber law expert who is also the managing partner of Law Office of Karthikeyan, a reputed law firm based in Chennai. He specializes in intellectual property law, cyber law, and other technology laws. He is a certified cybercrime investigator and a certified cyber forensic analyst. He has completed the prestigious course International Practice in Intellectual Property Law offered by the International Bar Association, London. He has successfully completed the qualifying bar exam of England and Wales. He gained rich experience from the barristers and solicitors practicing at the Royal Courts of Justice, England and Wales. He is an official guest lecturer on cybercrimes and cyber laws at Central Bureau of Investigation, Tamil Nadu Judicial Academy, Tamil Nadu Police Academy, Tamil Nadu Directorate of Prosecution, and National Academy for Customs, Indirect Taxes, and Narcotics. He regularly delivers lectures on intellectual property law and information technology law at various government institutions, non-government organizations, and other institutions. Navi sir, I now hand over the floor to you. Thank you.
Thank you, my friend. We are Indeed honored with the presence of Honorable Justice Mr. Swaminathan, particularly towards the end of the day. Okay. So morning we had one panel discussion. If that was a one-day cricket match, this will be like a T20 match. Okay. So let panelists speak too long. I've already shared some questions with them, and that's why I call this panel discussion as anchored panel discussion. Okay, so we will be able to quickly cover more ground, that is all, because each one of them are experts in their own field, and they are capable of holding the session for a long time. So I hope all of you please keep your responses crisp. We will always have supplementary questions to the extent necessary, and we are sure that there will be questions from the audience also. We will cover more ground. Okay. So the basic theme of this particular session is the data protection related discussions. India is just on the threshold of the DPDPA 2023 having been passed, but we are all waiting for the rules to come. I represent, of course, the industry, and I have been telling the industry, don't wait for the government to come up with the rules. You start compliance, because compliance is a journey, and for the industry, it is not like lawyers, that we don't want anything to go wrong and then the lawyers will come in. We want to be compliant. To be compliant, it is not necessary that I have to wait for long. I know what is the legislative intent of the government as of today. Government has also come up with a draft of the rules. Whatever is the early draft, I call it as version 1. And those of you who know, I have a website called dpdpa.in, where there is a link to this draft rules also. So I consider both DPDPA 2023 Act and this draft rules as indicating the legislative intent of the Government of India as of now, whatever it is worth. When do we say there is a legislative intent? This is the direction in which law is likely to take place. In fact, even before this act came, at least one high court in Orissa, another high court in Delhi, they actually made reference to the earlier PDPB bill, okay, in their judgment. And of course, they have made references to GDPR. Though they are not directly relevant to Indian this thing, when it came to right to forget discussion, they have made references to GDPR as well as the bill, Personal Data Protection Bill, which virtually had very little significance, you can say. But from that bill, we have now moved to the act. So this should be more, you can say, important, and I am sure that courts will definitely take notice that there is an act, even if there is no rules. So we will discuss that. One of the burning discussions in our legal circles, Karthikeyan was also asking about it in the morning. I did not give my views at that time. We will have it in this discussion. But before that, we know that the discussions on this DPDPA 2023 started because of the famous Puttaswamy judgment. So Puttaswamy judgment basically was to provide protection to the right to privacy. Okay. Now, if you go through this DPDPA 2023, there is no word called privacy in the entire act. Okay. So, has this legislation completely ignored the Puttaswamy judgment is a question which comes to our mind. Of course, Puttaswamy judgment spoke about information privacy. That is, the need for this regulation is because there is a need to protect the personal information in digital form. In fact, this was the same logic which USA used when they introduced HIPAA. 1996, one of the arguments for introducing HIPAA was that healthcare industry is using too much of digitization, which will have the frauds, and that is why HIPAA actually is Health Information Portability and Accountability Act. Though we recognize HIPAA as a very important privacy legislation, the name doesn't contain privacy or data protection. But of course, inside you had what was called a privacy rule. So now we are more or less in a similar situation where there was a important Supreme Court decision following which a legislation was passed, and Justice B.N. Srikrishna himself submitted a report along with a draft bill, that was the PDPB 2018. Then with parliamentary oversight, it became PDPB 2019, DPDP 2021, and finally the current version. So let us look at this issue. I think I should go to the lawyer in our forum, okay, of whether DPDPA 2023 is consistent with the Puttaswamy judgment.
This Puttaswamy judgment speaks exclusively on privacy as well as the information which is considered to be private. Whereas the DPDP Act, the name itself conveys digitized personal information, not privacy per se. So when the information has been digitized, then it will be governed under the DPDP Act. So privacy is completely different and digitized personal information is completely different. So it has not properly addressed the judgment.
Okay. In fact, Justice Puttaswamy, we had the occasion to honor him last year from my organization, that is Foundation of Data Protection Professionals in India, and honored him as Privacy Pitamaha, because he was the person who actually started this discussion at the age of 92. When we met him, he was 98. Okay, so we went to his house and gave the award and other things. So one of the popular views is what Karthikeyan said. Okay. Now we'll go there slightly in a different route. Section 43 capital A of Information Technology Act spoke about sensitive personal information and body corporate's responsibility to protect it with a reasonable security practice. So industry recognized it as SPDA rules or something of that nature. And if you go back to that rules, you will see that every aspect of what we discussed today, like obtaining the consent, ensuring some rights protection, avoiding cross-border reference, having security, all these are part of the 2011 SPDA rules. There is nothing rules, except that that was rules, whereas DPDPA is an act. So sensitivity at that time was there, and what was happening is personal data was first classified into sensitive personal data and others. So there was recognition for sensitive personal data. Now what government has done now is, they have said, we don't want to segregate personal data into categories. We want to segregate the data fiduciaries into significant data fiduciaries and others. And in significant data fiduciaries, we will say, depending upon the volume and sensitivity, depending upon the risk to the data principle, we will define somebody as a significant data fiduciary. So it is not that the legislation has completely ignored the privacy aspect, but they have addressed it in a different way by classifying the data fiduciaries. And in fact, this word of data fiduciary is a contribution by Justice B.N. Srikrishna, and that is a globally important observation we have to make. The moment you call somebody fiduciary, he is a trustee. So if I hand over my personal data to you as a trustee, you are more responsible than me. It is not that I have given you a letter and you have to tick 1, 2, 3 and say that whatever you have asked, I have done. Okay. You are supposed to know more about it than me, so you have to take care of my beneficial interest. That is why if you are handling, let us say, personal finances of a minor, you can't expect the minor to tell you what shares you can buy, when do you want to sell or something like that. You as a portfolio manager is expected to take that decision. Same concept comes when you talk of fiduciary. So India has adopted this principle that the person who decides on the purpose and means of finance will be called a data fiduciary. Just that use of word fiduciary expands the responsibility of the industry, and it goes beyond the instruction sheet, privacy, what is the permission, etc. So I have a feeling, I will ask my other friends also to react to this view, that by taking note of the significant data of fiduciary and linking it to sensitivity and harm, have we not tried to bring the concept of privacy somewhere here? What are the advantages and disadvantages we will see later on. In the corporate circles, I have several things to know, say why this is perhaps a better this thing. Now, I would like my friend here to say that whether the approach of the government to make significant data fiduciary defined rather than sensitivity, is it a wise move, or is it something which all of us understand, or does it require more explanation?
Thank you, sir. First of all, I would like to thank Honorable Navi sir for initiating this panel discussion and for guiding us the further path and the modality of this panel discussion number 2. The first question that we are going to deliberate, that we are going to discuss and we are going to put forth our opinion is surrounding the Puttaswamy judgment. Now, I have a different outlook, I have different take so far as Puttaswamy judgment is concerned. This act passed by the legislature is one of the laws in furtherance of privacy. It is not the only law dealing with the privacy, it is one of the laws. Reason is privacy cannot be defined so easily, and that is what the reason neither legislature nor judiciary has tried attempting defining privacy neither in the judgment nor in the statute book. Now, coming to connecting this law with that of the privacy judgment, that is Puttaswamy judgment, would be a wrong connection. Reason being, we have to understand the background of Puttaswamy case. The background of Puttaswamy case is not the private entity. The background of Puttaswamy case is not the wrongs which were being done by the private entities. Of course, private entities misusing the personal data of the individuals, that was the major concern. And we were struggling for that also. But then the background of Puttaswamy was something different, and that was UID, the unique identification of the India, that is the Aadhaar system. And it is the Aadhaar system that, compelled civil society to approach Honorable Court, Honorable Apex Court of the, Honorable Supreme Court of India. And Honorable Supreme Court has revised the Indian jurisprudence about the privacy, and in the wake of proliferation of cyberspace, activities, this time Supreme Court decided, let us declare privacy as a matter of fundamental right. So in the background of a public question, public interest and involvement of state and the interest of state, they decided that privacy is a fundamental right. So now privacy judgment delivered by Supreme Court is just the Supreme Court has defined privacy rights between state and the citizen, not between the private entity and the ordinary customers and consumers. So that is yet to be defined. Now coming to this act. So of course this act is not, it's just one of the steps in furtherance of Puttaswamy judgment. However, I agree with you, sir, that the privacy word has not been used. So that shows that, this law is not about privacy, this law about data, right? Processing of data. The central theme of this act is the processing of data. When data is to be processed, how data is to be processed, and what is the manner and modality of processing data. And instead of privacy, they used other terms, that is maintaining confidentiality of data, maintaining data, when data is to be made available to the third person or to the customer, and when data is to be made available for the processing by the data fiduciary. And they also use integrity. So confidentiality, integrity and availability of data. These three expressions they chose instead of going for privacy, because privacy is difficult to define. Perhaps that's the reason that privacy is difficult to define. That's why they have chosen confidentiality, integrity and availability of. Confidentiality means, a person, I may expect that my data is not to be revealed to somebody else. So my expectation is involved. Expectation is also involved in privacy. So confidentiality, this data must be kept confidential. This data must not be referred to by a third person unless consent is given, unless notice and to reply notice consent is given by the data principal. So now privacy. Now if we include privacy, that yes, this act has codified privacy, there is another danger that we are landing in, and that being that privacy, Supreme Court has declared it as matter of fundamental right. But if we read privacy in this act, it is reduced to the level of legal right. So something which was a fundamental right is now reduced to the level of legal right because of the statute. So again, this area we have to explore, that something which Supreme Court has declared is a matter of fundamental right is by virtue of these provisions is becoming a legal right. So that is perhaps another reason why privacy word is not used. This is my understanding goes. So that's all from my side.
Thank you. Rightly you pointed out the justification that it doesn't matter much as long as you are trying to protect the digital personal data in such a manner that it will protect certain rights which you recognize as important. It should be okay. Now let me go to Mr. Ranjit. Now DPDPA 2023 tries to protect certain rights. In fact, ultimately we come to that rights. Okay. Now, what are the kind of rights which are protected under DPDPA 2023, and how much they actually try to protect the privacy? We are talking of right to access, right to correction, then grievance redressal.
Actually, so before going and seeing this DP Act, I was reading this OECD report on data privacy. In fact, I could see a lot of reflection from OECD. OECD means Organization for Economic Cooperation and Development. And if you go to their website, you can download this report. So, the data fiduciary, data controller, and the data subject. So, they have given a lot of model rights, which many countries have adopted. And it is on that basis, India also has adopted certain thing into the Data Protection Act, where the data controller and the data subject, even though different names have been given, it's nothing but a reflection from the OECD rights. So it's not only privacy, as rightly said by my co-panelist. The word privacy is not mentioned in the Act. So it doesn't mean that Justice Puttaswamy's judgment has been ignored completely. But when you analyze the Act in depth, the various rights which have been enshrined to the parties are reflecting the privacy, confidentiality, integrity, and also make sure that there is some remedy when there is a violation which is taking place. So the remedial rights have also been given.
Thank you. So this is what highlights the need for us to interpret the legislation properly. Okay, now there is one right in our particular act called the right to nomination. Okay, now I want Karthikeyan to respond to this. What is the implication of this right to nomination? Normally, nomination is for a property. On the death of a particular person, it is transferred. Now, does it mean that we have finally defined personal data as a property? This becomes a very important, fundamental, I think, issue. Karthikeyan, now tell me your view on that.
Of course, there's no doubt in it. Data is considered to be an asset. I see the DPDPA Act as an extended version of Section 43A of Information Technology Act, which describes about data. In that, if you could analyze things, a lot of things we can get into a clear picture that data is considered to be, even diminishing a value of data is also considered to be an offense. So diminishing value of a data is considered to be an offense means you are valuing a data. Value means it is considered to be an asset. So accordingly, each and every one of us creates value to our work, whatever the work that we execute. That is, since ages, we know that intellectual property rights. Intellectual property rights is nothing but, it's, something born out of your intellect. It's only a data. There's no existence. It's an intangible property. Similar to that, the extended version is the data. So definitely there requires a nominee. We have a Copyright Act, Trademark Act. It's all only data. We have different nomenclature such as Copyright Act and Trademark Act. But however, it has its own validity. It is like a property where you can transfer, you can assign the property to third party, you can sell it. The same thing applicable to data as well.
Okay.
Yes.
Now, today morning when I was discussing with Ranjit, I think even yesterday, we were discussing that way back in 2000 when I took a class for the Ambedkar Law University, at that time we had one case of internet data theft. Okay, that is somebody in Delhi had installed an internet. Okay, so somebody from the BSNL or somebody came and set up the internet connectivity, which included setting up of a password. Normally, somebody should say that as soon as the setting up is over, he should ask this person, please change your password. Either he didn't inform or the person did not know. That is why he had his assistance. So next day, he had bought 100 hours of internet. Next day, it became 0. Okay. So the question came, it went to the court actually. Okay. What is the offense which has happened? The internet access time, which was contractually acquired by payment of some consideration. At that time, 100 hours meant 17,000 rupees or something like that. It was not small. So, what is the nature of that data was being discussed at that time. Similar things we have discussed in domain names also. What is the nature of the property domain name? There have been, I think, a Poland court which finally once said domain name is a property. Okay. It is a contractual nature, but it is a property. So when this case happened in India, we were also discussing, people were actually booking the case under IPC as theft. So I was saying that it is not necessary to make it as theft because it is not a movable asset. Okay. So you cannot apply the IPC, then IPC. It was not correct, but I think finally in Delhi, that was how it was done because one senior lawyer, I think he approved about that. That is different. But 24 years later now, we have a law which says data is a property which can be bequeathed, which means that there is very little doubt now that it should be considered as a property, whatever may be the value. Now, today people talk of NFTs, Bitcoin passwords, which are there in our email ID. They are having value of a very large amount. So, when we say data, we no longer look at a password as a data. Password, as people are discussing today, is an entry point. So if I get the password for your Gmail account and I explore that, then I may get your bank account details, I may get the other details. So data has got access to other data. So when we say that it can be nominated, now what this act is telling is that at the time of starting a relationship, which is at the time of taking the consent, the data principal should inform the data fiduciary that on my death, so and so is the person who has to get the control of this. Now, if you look at ITA 2000, section 1, subsection 4, it says that any electronic document which is of the nature of transferring the property on the death of a person, which we call as a testate document or something like that, is not recognized as an electronic document. So, which means that you cannot get the consent in an electronic form and end of it you add that nominee, so and so. DigiLocker does it even today. Okay. So it can be taken perhaps in the form of a physical will, but not here. But now a time has come for us to discuss this nomination right. Does it redefine all these thoughts? One, this is a property, and Second, of course, it is to be possible to be bequeathed, and it overrides the section 1 subsection 4 of 88 2000. These are all the things which definitely Justice Swaminathan will have discussions in the court at some point of time. But this is the jurisprudence which has to develop. I am always fond of saying things which might not be defined, but we have to interpret. Okay. So anyway, that is the nomination as a right, which is the fourth right. Grievance redressal is given as a right. Confidentiality, integrity, availability is under the obligations. This act, whereas GDPR talks about confidentiality, integrity, availability as part of the rights, including withdrawal of the consent, data minimization, data retention minimization, all these things are listed in GDPR. But we have taken a different route, that in the obligations of a data fiduciary, having appropriate, when you say appropriate, it's a risk-based protection, appropriate security, which is confidentiality, integrity, and availability, is a responsibility of the data fiduciary. So that is how that is brought in. That is another innovation. Then, when our law took up this consent as the major way of establishing legal basis, okay, what we have done is that unlike the GDPR, which provides alternatives, we say consent which is of the grade of an agreement, which means that there should be a notice which is offer and an acceptance. Only that is recognized as consent. And if you look at the draft rules which the government has now put in for discussion, they have even said that this consent artifact should be digitally signed. Interesting for you to note, okay? It should be digitally signed not only by the data principal but also by the data fiduciary. Why? Because in this consent artifact which is suggested, they say that there should be an undertaking by the data fiduciary that this data will be used only for the purpose for which I have taken the consent. Which means that when that is digitally signed, the person is actually giving a signed agreement that if he misuses that, like we have been discussing WhatsApp and other people, they take consent for one and use it for others. If they adopt this new consent artifact, you have a breach of trust case against them, I suppose. Okay, the lawyers will perhaps decide. So, consent artifact, as we have designed, whether it will be finally done in the same manner is different. But I just want to highlight, India has approached this differently from GDPR. So when I was talking to students, I was telling that we should try to justify the Indian approach. We should not say that GDPR, whenever we discuss, people say, please give me comparison between GDPR and this. I say that that is only there for academic interest. In the examination, if you want to have a question, fine. But when you want to criticize Indian law, don't say because GDPR had it, this also should have had it. That is where our national law schools have to come forward. And I was telling somebody may not like it, national law school people are willing to take cases against the intermediary guidelines. Of course, Shreya Singhal case is actually a national law school student, if I remember correct. Delhi. Yeah. Law school. Okay. So I want the national law school as a body to look at how you can defend the regulations, and in the process have policy advocacy and provide the guidance to the ministry. That should be the approach. So whenever you take some kind of research or something like that, keep it in mind. In fact, recently there is a case in Delhi which is going on between WhatsApp and the Union of India. FDPP has impleaded in that case because it is a case between WhatsApp and the Union of India against the intermediary guidelines. But we say that the certain averments made by Meta are all false. Okay. Now, if the court doesn't recognize, then decision will come on the basis of a false averment. Like end-to-end encryption is there, it cannot be broken in identifying the original person or something like that. So we want to actually explain it to the court if they give us an opportunity that don't go everything by what the WhatsApp has said. It may be a big company and ministry may not actually challenge it also. The problem is ministry also may just keep quiet. In fact, otherwise Shreya Singhal case would not have happened the way it happened. After all, this Palgar case, it was a case of 66A was for not for data, publishing of data. It was for transmission of data. Okay. But Facebook case was taken under that, Twitter case was taken under that, and finally they came up with the judgment, which I feel that if the courts do not take proper view, we will continue to have such decisions. Okay. Anyway, this is just to pass on some of thoughts so that in this August audience, something positive can happen. Okay. Now, ITA 2000 is the current law, which applies to all data, personal, non-personal, everything. Now, section 44 of DPDPA says that section 43 capital A of the ITA 2000 will be replaced as soon as this act becomes effective. Now the question comes, as Karthikeyan has been telling, do we think that DPDPA is effective today? When will it become effective? Will it be effective when notified? And the notification should say that section 44 no longer applies and DPDPA will be applicable. That is the ideal situation. Today that has not happened. But ITA 2000, again you should appreciate the wisdom of lawmakers, used a terminology called reasonable security practice and due diligence. What do you mean by due diligence? You have to look at the environment, what is the best practice, and adopt it. That is where I say that legislative intent should we not consider it as the due diligence. Okay. So on this point, let me hear Karthikeyan. He has got some specific views, lawyers' views. Yeah.
Of course, when we have section 43A, a special adjudicator has been appointed for this purpose, and moreover, he is an IT secretary. He is able to understand what is technology, how technology interacts with the data, and how data has been executed and processed, and how to secure the data, and if it is misused, and what are the statements made by the other end. Most probably in these type of cases, the other end will be the bankers. Bankers may say all this, technological names, different terms, but IT secretary could be able to understand that whether it is by such a way or not, and accordingly he will pass an order. So section 43A is very helpful for victims because normally in most of the cases, if we speak about hacking, something like a victim will come before the police station and he will file a complaint stating that my bank account has been hacked and accordingly I have filed a complaint. But bank account has been hacked means only bank server has been hacked, not individual mobile phone or laptop has been hacked. So who is the victim here is the banker, not the account holder, because it's again a fiduciary relationship between the account holder and the bank. He deposits his money with the bank and bank takes the sole responsibility to maintain that. But as on date, none of the bank had filed a case against the hackers, the unknown hackers. And moreover, in most of the cases, even the victims approach the bank, they lost money because of hacking. Normally, the prototype statement given by the bank says, please go to the police station and file a complaint and get a CSR, FIR. But of course, that is not required because it's already, we have a relationship with them and it is their fiduciary duty to, compensate the account holders and moreover compensate in the sense, not only the, reversing the amount which he lost, also compensate for the mental agony for them suffered because of the loss of the money. Because if he holds that amount in his residence, maybe by cash, he will be safe. It will be safe because if something goes wrong, he takes responsibility. But he entrusts the bank to hold his money, and something goes wrong. we have an option to file a case against the bank, but we don't know what is going to happen under Section 44 of DPDP Act, whether banks will come within the purview of DPDP Act or not. That will be another question.
Section 44 only says that amendment to this following acts will happen simultaneous with this, that's all.
Yes.
So in that, this repealment of section 43A is part of that.
Yes.
But that determines the date when you switch over from 43 capital A of ITA 2000 to the entire DPDPA, not one section of
Yes.
DPDPA.
Yes.
Now, coming to this applicability of the banks, okay, we'll discuss that. Let us look at NLU. Is DPDPA applicable to NLU? Yeah, you please tell me. Yeah. Is it a significant data? Should we do that?
Now NLUs or any university for that matter, they fall within the category of a concept called legal person. And data fiduciary has been taken to mean as person only. And person includes any association of person, any state, any entity, and any body corporate. Although body corporate expression has not been used, but almost all examples which had been used in IT Act, same examples have been used in the section 2 as well, so as to include body corporate. So yes, university is a body corporate, and it processes data, it collects the data, and it gives services with respect to data. Hence, it should be called as data fiduciary.
And in fact, education institutions hold data for a long period of time. And there are many engineering colleges where persons will perhaps join when they are minors and they become major. And then that results and other data will remain until the lifetime. So the educational institutions have a lot of responsibility, and perhaps they may become significant data fiduciaries. Now, if an organization is a significant data fiduciary, three major obligations have been specified under the Act. One is appointment of a DPO. Another is appointment of a data auditor. And third is to have a DPIA. So now Vijay Kumar has to start thinking who has to be the DPO of NLU. Difficult question to answer, but we should start thinking about it. Do you agree, Mr. Ranjit?
Yes. Once the act is, rules are framed, compliance is a matter which has to be done. But again, we see a lot of organizations in our country do not comply many laws. So it's a fact that we have to check and see which are the organizations which are going to comply or not. But in paper, yes.
Yeah,
Sir,
see.
I have a different outlook on that, sir,
Yeah,
if I may
please,
be allowed to.
please.
Now, this data impact analysis and the data audit, which they are insisting for significant data fiduciary, I think we should go, I think law should go, or the organizations or even executive should go beyond the parameters of law, and they should issue some notification insisting and making it compulsory for all, even small organizations who are processing data, to have a compulsory data audit, like, you know, we do audit of accounts, we do audit of safety audits, we do. So similarly, like that safety audit, legal audit, and accounts of data audit of our accounts, same way, even audit of data should be carried out irrespective of which type of entity you are, whether you may be a significant entity or non-significant entity.
No, the law simply says that if you are a significant data fiduciary, you will be liable. But the law and even the rules has not taken the trouble of defining a significant data fiduciary. Like Supreme Court in the Puttaswamy judgment did not take the responsibility of defining what is privacy. They talked around it and they did not come with it. Yeah. Now, here also I am told by the ministry that let the people decide whether they are significant data fiduciary or not. That is where the volume and sensitivity is one criteria. So every organization has to say, do I have sufficient volumes? Do I have sensitive information? Do I have processing which causes harm to the data principle? These are judgments which the organization is supposed to take. Of course, we have suggested to the ministry that at least give them an opportunity to apply to you to clarify whether I am a significant data fiduciary or not. In GDPR, there is such a provision. But if it doesn't come, then sectoral organizations, for example, NLU together, you can come together and develop some sectoral regulations and then go to ministry and say, should we consider all NNLUs as significant data fiduciaries? Some action like that is required. Otherwise, normally in the private sector, we say banks are significant data fiduciaries. Healthcare is a significant data fiduciary. Educational institutions are forgotten. People don't remember that they have significant data, and the law does not distinguish between one kind of organization and another. So this is one of the important aspects. Yeah, please go ahead, go ahead. Go ahead.
On this point, I have one clarification to be made, and that clarification may give some clue or solution in this regard, how to identify significant data fiduciary. In 2021, Ministry of IT Affairs have released one regulation called, under IT Act of course, under Information Technology Act, Intermediary Guidelines and Digital Media Ethics Code 2021. In that, what they have defined, depending of number of subscribers and depending of volume of your business and volume of reach to the customers and data principles, that entity could be classified by the government as the significant social media entity. So can't we decide this significant data fiduciary similarly on the basis of what government has done under the Intermediary Digital Media Ethics Code 2021?
Agreed.
So that is one clue that we have taken from those guidelines, and we can accordingly interpret.
Yeah, government has so far has not bitten the bullet, as we can say.
Social media sites, they are significant.
They have taken 50 lakh
Yes.
subscribers as the criteria, and in one part of the rules, they use 2 crores as a kind of this thing. We don't know whether that will be one of the criteria. But I will come to the last question. I think at 5:23 is what my friend said. Okay. Another important aspect is, see, this DPDPA Act does not provide compensation to the data principal. Okay. Normally we expect a privacy protection law to provide some kind of a protection. But if you look at the penalty clause, there is a 10,000 rupees fine to a data principal if but there is a logic and reason. If they provide false information, see, this act has gone with the new generation thinking that there should be duties to people also. So the data principals also have a duty. Duty not to make false complaints, duty not to impersonate, and in fact, duty to be law abiding. Okay. I think we should appreciate that. In fact, that under the same way, when we said data fiduciary, we are saying fiduciary also has got a duty. So that is there. But now, one thing which I would like to ask Karthikeyan, who has actually done many successful adjudications, is if there is a data breach, while the Data Protection Board may actually provide 200 crores, 250 crores, whatever is the fine, there are many individual data principals who would have suffered a loss. Can they go to the adjudicator of ITA 2000 and make a claim for compensation?
Yeah, the power to the adjudication was given under Section 46 of the Information Technology Act, whereas, the way we approach the adjudication lies with the 43A. Though 43A has been abolished, 46 remains.
Yeah.
46 remains. We have an opportunity to approach, but whether the powers has been overridden through the DPA or through this adjudication officer has to be verified only when the rules comes into picture.
Now, there is Section 43 of Information Technology Act also, which is more generic.
Yes.
43 capital A was for reasonable security practice to be followed by body corporates, failing which there will be compensation payable. But Section 43 was for various other reasons. If a person has suffered an adverse impact of any contravention of ITA 2000, he can seek compensation
Yes.
by providing the evidence to the adjudicator that I have suffered 10,000 rupees loss, 20,000 rupees
Yes.
loss. In banking, we know exactly the amount of loss which is there. So that remains, 43 remains.
Yes.
So if it comes under Section 43, and one more thing you have to remember, 43 is linked to section 66, criminal offense.
Criminal aspect.
Then 66C and D is impersonation and misuse of
Identity.
digital signature.
Yes.
So in any data breach situation, automatically these will come into existence. There is one other interesting observation which recently I was trying to identify. There is a section called section 66B in ITA 2000. That is, use of a stolen property by a person is an offense under his hands. Now, there are many people who create databases and sell to various organizations for digital marketing or something like that without the permission. Is it not equivalent to stolen property? And if any organization buys that data and uses it for marketing, can we invoke section 66B, which is actually a criminal offense? Yeah, you can add to that.
It can be, it's non-compoundable and...
So there are many sections of ITA 2000. Even after one section 43A goes, sections like 72A. Because again, another question which comes up in DPDP is, why is data processors left out? All liabilities are on the data fiduciary. Now I say there is section 72 capital A of ITA 2000, where a data fiduciary, if he has given personal data to a data processor for processing under a contract, that is, it contains personal data, and against the contract, if that person processes it in violation of the contractual terms, section 72 capital A speaks of 25 lakhs compensation. It's not compensation, it comes under, in fact, that is something which legally we have to find out. It was earlier under the chapter 11, okay, which was criminal offenses. So whatever penalty came was considered as payable to the government. Now, after this Jana Vishwas Act, they removed some of the criminal proceedings, provisions, and made this into a 25 lakh civil, payment of money, okay. Now, I don't know whether it's compensation or whether it can be considered as compensation or it should be considered as a penalty which the government only will take. You have any view on that?
Yes, sir. Sir, I think there is a great omission, major omission on the part of the legislature, and they have committed a great mistake by not adding compensatory provisions. I have a couple of reasons to justify my views. First of all, they made citizens, consumers, customers as data principal, and the expression principal itself has become now misnomer, because they have been subjected to the data subject. Data subject expression is used in GDPR. Here we have chosen data principal. We wanted to make customer as king. We wanted to make citizens as king. We always say consumer is a king. But we don't see citizens as king in this regard because there's no provision for compensation, and all these penalties are going into the pockets of government. There's a provision in the act which says whatever penalties which are imposed on these big techs and corporates, all this entire fund, all these penalties shall go to the consolidated fund of India. And now coming to IT Act. IT Act is the only law wherein for data breach there was a provision for compensation, and that being section 43A. And for plain 43 cannot be considered to be a provision for data breach because it is a contravention. It's an act of hacking. It is an act of unauthorized access. So 43A was the only provision in IT Act wherein compensation could be sought by customers against the body corporates. The same thing is now there, not there because of the section 38 of the DPDPA. So now DPDPA has virtually, literally wiped out the jurisprudence of compensation, neither in IT Act nor in DPDPA.
Okay, that's a view. You can put in your final words on that.
Yes, it was a comprehensive discussion, and I personally feel that the present law, but we have to wait and see the rules. Once the rules have been notified, Union Law Minister has said within 1 month, the rules will be notified. So how it is going to sync and how effective and how it can be implemented can be tested only on that ground. Second thing is as our moderator was telling in detail, Always we are reading IT Act along with this provision of Act, even for various issues which are pertaining to data. So that challenge is always a challenge, because IT Act again could be replaced by another law. It's in the, so Digital India Act can come at any point of time. So whether that provision of Act will take care of all the concerns which our moderator, honorable moderator has said, is a real test, which we have to wait and see. So I think this is in a transit stage, so we have to wait and see, and maybe we need another conference to finalize everything.
Yeah. You want to say anything?
Yeah, see, ultimate aim of any legislation is to protect the individual as well as the interest of the individual. But we should not stick on to the procedures, because in most of the cases what happens in India is like we stick on to the procedure and we find lacunas in the procedure and also producing of evidences rather than concentrating on the solutions. So any law which comes into power, the rules has to be in such a way that it gives justice to the individual. That's it.
See, we are talking of ITA 2000 and DPDPA being considered together. Remember that even the Consumer Protection Act 2019 has a recent notification, I think it happened in July, on dark patterns. They have given a notification listing out 1, 2, 3, 4, 13 things which are called dark patterns. What we mean by dark patterns is a practice used by many e-commerce organizations to mislead a consumer and get him to buy things which is not required. In the earlier draft, there was something called psychological manipulation, was a harm. It was declared as a harm. Current this thing, it is not there. But now Consumer Protection Act 2019, dark patterns list actually comes under that category of the harm caused through psychological manipulation. So people who work on DPDPA will have to be aware of multiple laws which may have effect, and it is a great practice for lawyers. Okay, more confusion, the better it is. Of course, we will be talking to the industries and say, please try to provide appropriate mechanisms for compliance by design. That is what I have been working on in this DGPSI scheme. But lawyers also will have to come in that. I think we will close our session here. Thank you for the NLU for giving us an opportunity. This is a never-ending discussion. But anyway, it is just to promote further thinking about it. Okay, thank you.
Thank you all for that energetic and thoughtful interaction. I'm sure we all have a lot to learn from the outcomes of this discussion. And that brings us to the end of the technical sessions today. And now I hand over the mic to Ms. Aishwarya.
Good evening, everyone. My name is Aishwarya Madanan. I welcome you all to the Valedictory Ceremony of the National Conference on Cybercrimes and Artificial Intelligence, organized by the Tamil Nadu National Law University's Center for Research, Development, and Training in Cyber Laws and Cybersecurity. I hope all of you have had a very productive and fruitful day discussing the ethical and legal concerns arising out of the effect of artificial intelligence-based technologies on cybersecurity and the perpetration of cybercrime. I'd like to invite our Vice Chancellor, Professor Dr. V. Nagaraj, as well as our Registrar, Professor Dr. S.M. Balakrishnan, along with the Chief Guest for this evening, Honorable Thiru Justice G.R. Swaminathan, Judge of the Madras High Court, to join us on the dais.
A very warm welcome to one and all present over here. On behalf of Center for Research, Development and Training in Cyber Laws and Cyber Security, I welcome the gathering over here. At the outset, I would like to welcome our Chief Guest of the valedictory function, Honorable Justice G.R. Swaminathan sir, Judge Madurai High Court. Secondly, I would like to welcome Dr. V. Nagaraj sir, Vice Chancellor of Tamil Nadu National Law University. I would like to welcome Dr. S.M. Balakrishnan sir, Registrar of Tamil Nadu National Law University. I would like to welcome esteemed panel members of this conference who shared their views on the during the panel sessions. I would like to welcome chairpersons of the technical sessions 1, 2, 3, and 4. I would like to welcome paper presenters online and offline who are present over here. I would like to welcome the esteemed professors of this university and all those professors who came outside this university over here. I would like to welcome all of them. And lastly, we are highly honored to have all of you over here for this wonderful conference. This is the valedictory session now starting. I would request my colleague to come over here.
Thank you very much, sir. I would now like to invite our Vice Chancellor, Professor Dr. V. Nagaraj, and our Registrar, Professor Dr. S.M. Balakrishnan, to felicitate our Chief Guest, Honorable Thiru Justice G.R. Swaminathan, Judge of the Madras High Court. Up next, I would like to invite Ms. Deepika Shivkumar, Assistant Professor of Law, to deliver the report of the conference sessions and panel discussion.
Thank you so much. So a very good evening to everyone present here. So I've been given the privilege to say the report of this particular event, which was conducted successfully in TNNLU today on 21st/9/2024. So the National Conference on the Cyber Crimes and AI, which was hosted by the Center for Training, Development, Research in Cyber Laws and Cyber Security, TNNLU Tiruchirappalli, was organized over a period of more than 3 to 4 months, and it has been participated by more than 100 participants all over the country, both in offline and online mode. And the session kick-started with an amazing panel discussion, which was hosted and moderated by Dr. Nagaratna, and also resource persons from various parts of the country, including Professor Dr. I'm really sorry, including Professor Dr. Ranjit Oman and Dr. Aparna Vincent, and also Dr. Venkateshamurthy. And the session was action-packed and also discussed upon the various aspects of the cyber laws. It discussed upon how the technology was developed across in the country, and also the laws which are inadequate in the country with respect to the cyber crimes. And also it discussed upon how this could be implemented more, what are the various dimensional problems, the sectorial problems that we are actually having, including the problems related to the children's right, the digital divide, and also multi-stake participations, lack in multi-stakeholders participation and governance. Then we proceeded with the first session, the first technical session, which was actually conducted by Dr. Ashok Kumar Vache, and as well as Ashok P. Vache and Dr. Aparna Vincent from IIM Indore. The session had 10 papers with 2 online and 8 offline papers. The session dealt with lots of legal as well as the technological issues that was in and around the cyber crimes. The session was actually on the theme of cyber crimes in metaverse and digital divide, extended reality. And the session concluded with a jovial participation of more than 10 presenters in both the session, both online and offline mode. Then we had the second technical session, which was headed by Dr. Nagaratna and Dr. Rajeshwari from NIT Trichy. The session held was actually involving around the cyber crimes related to the artificial intelligence and robotics, and it included 9 participations from online as well as the offline modes. Then the session discussed upon the deepfake technology and also its ethical implications, and also why law is inadequate in this particular area to deal with the matters. And then we proceeded with the third session, technical session, which was basically upon the nature of the cyber crimes and its enforcement problems and issues. The session was moderated. The session was co-chaired by 2 of the eminent personals present over here, Dr. Ranjit Oman as well as Mr. N. Vijay Shankar sir. So the session also looked into the various aspects which are related to the cybercrime enforcement and the lack in the evidence part and how to deal with the matter. Then we proceeded with the last technical session, which was also related to the cybercrime enforcement, and this session was also headed by the professor. It was headed by Venkateshamurthy sir as well as Mr. Venkateshamurthy, and also with respect to with respect to this whole session. Then we proceeded with the final panel discussion, which was basically dealing with the privacy rights, which was moderated by Mr. N. A. Vijay Shankar sir, and the session were chaired with three of the most eminent personals we had, honorable persons we had, Ranjit Oman sir and Mr. Venkateshamurthy, and also Professor Dr. Ashok P. Vajje. So the session involved around the privacy violations, the Puttasamy judgments, the practical implications of applying DP Act, the Data Privacy Protection Act 2023, and also the implications of it having in the cyber security regime. So the whole session was concluded with an enriching participation from all the participants from various institutions. And to last to the note, the session was inaugurated with our Justice G. Swaminathan, G.R. Swaminathan, who took his time to come and spend his time the whole day with us, along with us, throughout the sessions to participate as a normal participant into all the sessions, getting enriched with all the academic insights that was given by various professionals over here. So I take this opportunity to thank the CDRT to give me an opportunity to give the report of the session. So thank you so much. Thank you so much, and I hand over the mic.
Thank you very much, ma'am. It's clear that we've had a very constructive and rewarding set of sessions today. Now I would like to invite our chief guest, Honorable Thiru Justice G.R. Swaminathan, Judge of the Madras High Court, to step forward and deliver the valedictory address.
Good evening to one and all. In the last session, there was reference to the Aadhaar judgments. So I thought in my valedictory address, I will start from that. And there are quite a few Aadhaar judgments, and in one judgment, I found one interesting quotation. Do you know who has been quoted? The Israeli Prime Minister Benjamin Netanyahu. I think today no judge would dare to quote him. But in 2019, there is an extensive quotation of one of his talks. What does Benjamin Netanyahu say in his speech? He said, times have changed. Now there is a confluence of data, connectivity, and artificial intelligence. And that has brought about humongous changes in every field. Israel, we are a great nation, as a great agricultural nation. And how this artificial intelligence has impacted our agriculture. We will continue to do our agriculture, but then how? The drone will be in the sky, the sensor will be on the field, and we will decide which plant will get how much water and what fertilizer will be given to which plant. And that is how. And therefore, our agriculture will now become precision agriculture. My young friends, please note what Netanyahu said. Agriculture will become precision agriculture. And borrowing from that thought, many people are saying whether the legal profession will die a death. And in fact, some books have also come with the title. But just as agriculture has now become precision agriculture, legal profession must become precision lawyering. I think this message, the take-home message from this conference for all the students here. You will soon graduate from this institution shortly, and you will continue to do really well in the profession but then you will do well in the profession only if you can do precision lawyering. This is the first thought I thought I would share with you. And I thought I will have one word of advice also for the young boys and girls here. In the morning, one ma'am, I do not, your name, ma'am. Your name? Hemalata, huh? Hemalata, but she was talking about, I think, Indianization, right? So she's hinting at that. And that is one thought that is so dear to my heart also. And some years ago, Justice Abdul Nazir of Supreme Court spoke about decolonization of the Indian legal system. And it was and it was quite a controversial talk also. And some persons belonging to the right-wing group requested me to translate that lecture into Tamil. But I am not good at translation. Therefore, I requested one friend of mine. And in fact, he has been evincing interest in, he has, in fact, has done quite a few translations also. They have been published also. I will not name him. So I called him and said, can you do this translation for me? I gave him the assignment, take it as yesterday. And within 24 hours, he comes to my chamber and says, sir, here it is. I was stunned. I thought, this man must be a wonderful guy. He has command over law. He has command over English and Tamil. What a wonderful man. See, I've been breaking mate for the last 1 week. Within 24 hours, he has produced a translation. But then, before publishing it, I thought I will just read both, do some comparison. And only those who know Tamil can enjoy this joke. Those who know the others may not be able to. Justice Abdul Nazir quotes some Shastra, which said, you call the dog mad and then hang it, something like that. The word mad dog was there in that English lecture. When I read the Tamil, friends, mad dog enna solveenga? சும்மா சவுண்ட சொல்லுங்க. மேட் டாக் தமிழ்ல என்ன? சொல்லுங்கப்பா. Won't you respond? மேட் டாக் தமிழ்ல என்ன? வெரினா. கரெக்ட். வாட் தர்ஷினினா? மோதர்ஷினி. வெரினான்னு சொல்லணும். ஆனா in that translated version given by my friend, it was written as a பைத்தியக்காரனாய். I was wondering how mad dog became Paithakarana instead of Verinai. I was shocked. I called my friend. I said, how can he do this translation? Then friends, let me, in the morning itself I confess to you, I am not aware of this AI, I do not know anything. Then he said, sir, don't you know, in Google they give the translation. This is a Google translation, he said. So mad means Paithakara, dog means Nai. Mad dog is Paithakarana in Google. But that is not how we translate. So this is one example. Then another one, this happened 2 days ago in my court. There is an act called Partnership Act. You know, if an unregistered firm cannot sue others because if it is not registered. That was a case involving an unregistered firm. Then the defense put forth by the respondent was, sir, this is not partnership. This is only a joint venture. Then I asked him, how do you distinguish between a partnership and a joint venture? He did not have an answer. He said, please give me 1 day's adjournment. I adjourned the matter. The next day, he passed on something. I said, then he was passing up the sheepish, smile on his face. Then I said, why are you feeling so defensive? I asked him. Sorry, Lordship, this is from ChatGPT, he said. Then the bottom there was endorsement, ChatGPT can commit mistakes. I was shocked. So my young friends, therefore, from the panelists here, I want you to learn something. See what the translation friend, what he did, and what this lawyer, just quoting this ChatGPT, these are things that you should avoid. See, I was closely watching all the panelists, starting from Aparna, Ashok ji, Navi ji, of course, is a veteran. Then my young friend Karthikeyan, then Venkatesh Murthy ji, then Professor Ranjit Abraham. See, they have all mastered the subject. And last session, I do not know how many students were closely observing, they are parsing every provision. Every provision. That is the way you must master the subject. So this straight away going to the artificial intelligence, invoking its help, or going to ChatGPT, I think that you should avoid. You can have it as a research assistance or help only, but then the basic reading, the hard, raw reading that you must do on your own. This is the take-home message I want you to inculcate in you. And today was a day well spent in my life. And this is not a valedictory session, it's more a vote of thanks. The institution, the Vice Chancellor, the Registrar, Deepa Ma'am, Deepika, all of them, and the panelists. And I was following the paper presentations also. The students are full of enthusiasm and energy. They had really done their homework. Therefore, I was personally benefited, enriched, and in fact, I will go with my head a little weightier. Of course, head weight means only if it is arrogance, it is bad. If it is knowledge, means it's good. So my head, I'm going out with a few more kgs added to my head. Thanks to the knowledge I got it today. And congratulations. The conference was extremely successful. All the very best, and my best wishes to all the students here. Thank you.
Thank you very much, sir, for your profound insight. I look forward to seeing the day when the legal profession becomes one of precision lawyering, especially in the realm of cyberspace, even in the world of AI and more advanced technologies to come in the future. I would now like to invite our chief guest, Honorable Thiru Justice G.R. Swaminathan, Judge of the Madras High Court, to distribute the Best Paper Awards of the conference. I will be calling out the names of the winners for the best paper under each theme of the conference. When I call your name, please join us on the stage. For Theme 1, the winners are Gokul S. and Pawan S.S. from School of Law Christ, deemed to be University, Bangalore, for their paper titled Cyber Insurance in Metaverse. Congratulations. The winners for Theme 2 are Varsha M. and Swarna Raksha from School of Excellence in Law, Chennai, for their paper entitled Extended Reality, the Impact of Cyber Kids in Gaming and Online World. We'll ensure that your certificates and awards are delivered to you. The winners for Theme 3, the winner is Jyotika V.S. from School of Excellence in Law, for her paper titled Deepfake Technology, Legal Implications and the Battle Against Misinformation. The remaining 2 awards under Theme 4 and Theme 5 go to online presenters. Theme 4 is won by Anaka Angelin from National Law School of India University for her paper entitled Leveraging AI to Negotiate Fairer Consumer Contract Terms. The winner for Theme 5 is Meera Patel from School of Law and Constitutional Studies, Shobit Institute of Engineering and Technology, for her paper entitled Legal Identity of Artificial Intelligence under Indian Law. Congratulations to all of the winners. For both the winners and all of the participants alike, your thoughts and ideas are the building blocks of the future of the intersections of law and cybersecurity, both in India and around the world. It has been a pleasure to host you here today. I would now like to invite Ms. Deepa Manikam, Director of the Conference and Faculty in Charge of the Center for Research, Development and Training in Cyber Laws and Cybersecurity, to deliver the vote of thanks.
Thank you, Ms. Aishwarya. A warm good evening on all gathered here. Actually, I've planned it to complete it at 6. I'll take 2 more minutes over 6, please. So, I'm here to deliver the vote of thanks. As the faculty in charge of Cyber Law Center and director of the conference, I take this privilege in delivering the vote of thanks to the session. First of all, I'd like to thank our honorable chief guest, Thiru Justice D.R. Swaminathan sir. Sir, thank you so much. So when we went to Registrar and I went to invite him at his chamber, so the first thing he said that I'll be there from the first session in order to listen all to the technical sessions. I said, sir, much privilege. He said, no, please don't say that. I'm a student. I want to learn everything from all of you, because he was going through all of the sub themes of the brochure, and he said, I just need to learn about it. In a word with Dr. Ranjit sir, we were just discussing, sir is so academic friendly, justice, and sir, you have proved it to be. Thank you so much, sir. We did not have the feeling that we are hosting a justice. It was so good, like in all of the panel discussions. Thank you so much, sir. We had even technical glitches, but you were all part of it, and you were so kind enough and warm enough in involving with all of us as part of our organizing thing. Thank you so much, sir. Thank you also for taking one day time to us to learn all of the new sessions. Hope to host you in future as well, sir. Thank you so much, sir. And I extend my warm gratitude to Professor Dr. V. Nagaraj sir, Vice Chancellor of the University. Sir, thank you so much for all of the guidance and support that he had given so far. For the past 4 months, I have went for all of his approvals, and never he said no for any of the requests that I went along with. Thank you so much, sir. And I extend my warm gratitude to Registrar Professor Dr. S.M. Balakrishnan, sir. And I am a proud student of you from Government Law College Trichy, standing here, who was the faculty in charge of Center for Cyber Laws. And sir, thank you so much for all of the travels that you have done along with me to invite the chief guest, and all of the permissions, so many tortured phone calls and so many things, direct meetings. Thank you so much for being so kind enough to me, sir. Thank you. I would like to move to the paper presenters because you are all the stars of the show today that had happened. Because in order to select 50 slots of papers, we received more than 450 abstracts. It was so hectic for the organizing committee to finalize with all the dummy numbers, and it took us 10 days to revise all of the, just look into all of the abstracts and select exactly 60 abstracts, having a cushion of 10. So thank you so much, all of you. And the paper presenters and who have come here were, today's session was 50 paper presenters, including co-authors, and we had 100 spectators across country, and so happy about it. Thank you so much for coming down to Tamil Nadu National Law University. We'll be hosting, we would love to host you in future as well. Thank you. And next, I would like to thank my most precious gratitude to panelists and resource persons. Dr. A. Nagaratna ma'am, who is the key success behind this conference. In a word with her, we were planning about sub-themes and all, so thank you so much, ma'am. And Mr. Na Vijay Shankar sir and Venkatesh Murthy sir, you were so kind in all of the phone calls we made, the torches we made for the requests for giving us questions for panel discussion, creating WhatsApp groups. There's so many things that we have done as part of organizing committee. You tolerated all of those things. Thank you so much, sir. And Professor Dr. Ranjit sir, thank you so much for coming down. Before even I could call you to book tickets, you said I booked tickets, I'll come on so and so day. That was all through just a phone call and a message. Thank you so much, sir. And special thanks for also accepting to be there in the second panel discussion as well, sir. Thank you. Advocate Karthikeyan sir, I know you had a very hectic schedule, and amidst this hectic schedule you are here. Thank you so much, sir. And Ashok sir, again, I'm a proud student of you from NLU Jodhpur. Thank you so much, sir, for being here and also the insights that you have shared with us. You were down with fever yesterday, you said, but still you took time to travel till Madurai and took a cab, came here. Thank you so much, sir. We owe you a lot. Thank you. Dr. Aparna Vincent, again, you are from Indore. I know the travel from Indore to Trichy is so hectic, but you did it. Thank you so much for the insights that you have shared with us. That was so incredible. Thank you. Dr. Rajeshwari ma'am, Professor of Artificial Intelligence from NIT Trichy, had accompanied us today morning. Thank you so much. And I would love to extend my gratitude to faculty, all of my faculty colleagues and well-wishers of the institution. And I would fail in my part if I don't thank organizing committee members and faculty coordinators. Dr. Faisal sir, thank you so much for everything that you have done. So in all of the minimal things, the hard work, smart work, whatever that I could put in, that was possible only because of you. Thank you so much, Faisal sir. Vedavalli, thank you so much. You did so many things since when we were just trying to go with the brochure. She was the one who was helping me a lot, and now we had seen limelight today. And Deepika ma'am, thank you so much for being with me throughout. I know that I've tortured all of you for so many months now. Thank you. And special thanks to Nidish sir, who's not here, but he had to leave. He had to be there in Bangalore for some other commitments, but he did food, accommodation and transportation arrangements today. That was very perfect. Thank you so much, Nidish sir. And I would like to thank my Cyber Center research assistant, Ms. Kriti Rachya, who was appointed 2 weeks ago, but she could give her fullest to me for the 2 weeks. Thank you so much. And my student research assistants, notably Mr. Raghu Devarakonda. Raghu, thank you for being a lifesaver for me since I've started discussing each and everything to you. You did planning very, very, very well, and thank you, Gokul Shankar. And I would fail in my part if I don't thank volunteers of the conference. Thank you so much, all of you. I'm not naming each of you. Whoever had lost sleep, whoever did not take proper food, you can take enough food and enough sleep today. I hope, thank all of you for being with me throughout all of my pains that I've been going through, and also today only because all of your hard work this conference had seen limelight. Thank you so much. And I'm sorry for saying all of the persons behind the veil at the last. I thank admin section, VC office and registrar's office, notably estate office. Thank you, EO Suresh sir, and all of the staff working under him. Thank you for all of the help, including all the staff that he had assigned to work throughout for the past 2-3 days. It was hectic for all of us, and specifically thanks to IT support, Peter sir, Arul sir and Sendil sir. Thank you so much. And also in and out technicians who were here, and you coordinated, thank you sir, well with our IT section, and that was a great success that you had given us. Thank you so much again. And finally, I would like to thank our housekeeping staff and gardeners whom we were torturing for the past 2 days very badly. We gave them all physical works. Thank you so much for all whatever you have did. Whomsoever I missed it, if I missed it, I'm so sorry. Accept my apologies. But all of you made it a successful, this conference a successful one, because only it has seen the limelight, and it has seen the light only because of your strenuous effort and dedication. We all can grow together to make this institution and set it in the right and the highest place. Thank you so much, all of you.
Before we wrap up, we have our winners for Best Paper from Theme 2 who are here with us. So I request our chief guest, Honorable Thiru Justice G.R. Swaminathan, to distribute their award. Congratulations to Varsha M. and Swarna Raksha from School of Excellence in Law, Chennai, for their paper entitled Extended Reality, The Impact of Cyber Kids in Gaming and Online World. Thank you, ma'am. You've left out nobody except yourself, so I want to thank you, Ms. Deepa Manikam, for being the backbone of this conference, and without whose guidance none of this would have been possible. Again, to reiterate, I'd like to thank the faculty coordinators, Ms. Vedavalli, Ms. Deepika, Dr. Faisal, and Mr. Nidish Kumar, as well as the research assistant for the center, Ms. Kriti Rachaya. I would like to thank the student coordinators and volunteers for dedicating so much of their time and effort to making this conference a success, as well as the administrative staff, IT support, and all of the maintenance staff working behind the scenes to ensure that this event goes smoothly. Finally, I'd like to thank all of you, the participants, for joining us here today, as well as our esteemed panelists for being here and sharing so much of your expertise. None of this would have been possible without your constant support. With that, we have officially reached the end of the National Conference on Cybercrimes and Artificial Intelligence 2024. Thank you all once again. Please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलति तरंगा तव शुभ नामे जाहे नव शुभ आशीष माहे गाहे तव जय गाथा जनगण मंगल